technology, diversity, wine, the redwoods, and everything in between. Welcome to the Northern California Bay Area, and one show takes you inside the real estate that makes it all happen. This is By the Bay.
Hey everyone, and welcome back to By the Bay. I'm your host, Dan Ancheta, and I am grateful that you are here listening or watching on Apple Podcast, YouTube, or Spotify, wherever else you might be finding our podcast. So thank you for being here. I have an awesome guest today. Brett Rhodes is here. He is the proprietor of Rhodes Law, Estate, and Trust Attorneys in Santa Rosa. Thank you for being here, Brett. We met through a number of kind of mutual connections. We'll do some name dropping of the Juliana and Chelsea Runnings, I think, also recommended that we get together. So good to see you. How are you today?
Yeah, I'm doing great. Thanks for having me.
Absolutely.
I think it's great to be here. What you're doing for all your listeners is an excellent thing. And I'm happy to be here and share at least what I do with your audience.
Yeah. So why don't you introduce yourself, because you're like the type of law you practice is pretty specific. You're not like, it's interesting as I'm meeting more attorneys and stuff. Sure. It's like you either have the ones who are super niche down, they do one thing, that's what they do, or ones who are kind of like, I do this mostly, but I also dabble in this and dabble in that, and I'll do that for on occasion if the case is right. So how do you practice law? Tell us about your practice.
So I practice exclusively in estate planning. I do some mediation, but mostly just estate planning. I grew up in Sonoma County. I've been here since '86. I consider myself a Sonoma native, if you would.
For sure.
And went to the junior college, Sonoma State. Went to law school here at Empire College. So, I grew up here.
So deep roots in the community,
yeah.
Kind of understand the culture of things and kind of like how all the things move around and work here.
Yeah. I think we are very fortunate to live here in the North Bay, specifically Sonoma County. It's great, but I know, a lot of the counties that surround us, all great places to live. I mean, just all in Northern California.
Yeah, that's awesome.
We do have our challenges, obviously, with wildland fires and those things, but overall, great community.
Yeah, for sure. And I mean, it's a relatively affluent, relatively educated, part of the country. And I think that speaks, to the types of businesses that are here and the type of, the way their economy works. So for your specific practice, I guess I'm curious, because I get this question all the time from home buyers, at what point do you recommend that a family start a trust, right?
Sure.
So first of all, I guess we should go back and answer what the heck even is a trust and why does someone need one at all? And then maybe answer the question of like, at what point do you need one?
Sure. I mean, it's a lot to unpack, right?
Sure.
So, and that's the biggest thing about estate planning, whether you see it in the newspaper or on the news in any format. Right. There's a lot of myths behind it and there's a lot to unpack.
Right.
And so
I feel like the common misconception is like only super rich people need a trust.
Sure.
Right. Because you hear of like, trust funds and that sort of thing. Like that's kind of what we're talking about, but also not, right?
Yeah.
So can you break down for us, like at what point, what is a trust? Why does someone need one? And when should they establish one?
Sure. So, a trust is really a legal document that allows people to provide for their life and legacy, transfer their assets, generational wealth, a distribution plan. It's pretty robust. The good benefit of a trust is it bypasses the probate process here in California.
Okay, so what is probate?
What is probate,
yeah.
Right? So probate is a legal process where the courts get involved. If you don't have a will and you do nothing in California, you're going to probate.
So if you have your assets, you have your house, you have a car, you have some stocks and bonds in your 401k, like a average American does, right?
Sure.
And you die, and you don't have a plan, then the court decides who gets your stuff.
Absolutely. That's if you do nothing in California.
Okay.
If you have a will, and that's one of the misconceptions, right? And the other myth about, hey, only for the wealthy. Anyone over the age of 18 should have some level of estate planning,
okay.
Even if you're living at home with mom and dad.
Okay.
Advanced health care directive, durable power of attorney, and a will for anyone over the age of 18. And you'll see this a lot when kids go off to school.
Okay.
Sometimes the school will encourage that.
So advanced healthcare directive, that is basically if I'm hurt and I can't make a decision what's to happen for me, and I'm married or not married, right? Like, who has the right to make the decision for me?
And that you've kind of already made some decisions. Advanced healthcare.
Okay.
So you've already kind of outlined what you want to do. I don't want life-sustaining efforts. I don't want this done. I don't want that done. And then it designates, people, decision makers for that. So, overall, unpacking estate planning, it's a whole list of tools that work synergistically. So it's not just a trust and we need to protect a trust or we need one document. But as you age, and this kind of goes into your question about, who should have a trust. As you age, you're collecting more assets, a bank account, a car, a retirement plan, a house. You start to have kids, right? More and more starts to expand. You need to be able to have tools in place to manage all of these things.
Okay.
If you don't, then you start having more of Swiss cheese here, or you have nothing, and then it causes a lot more legal problems down the line.
Got it. Okay, so I'm just thinking at like mile markers here. So if you're 18, right, you need some type of advanced healthcare directive and a will. Basically, if I have some stuff, here's what I want to happen to it if I die.
Sure.
Right. Advanced healthcare directive also covers things like organ donation and all those types of things, right?
Yeah.
What am I doing? Okay, so are those the only two that you said?
Advanced healthcare directive, durable power of attorney for finances.
Durable power. So if I'm unable to make financial decisions, I'm incapacitated for some reason. Someone can act as my attorney, in fact, and do things for me to pay my bills and manage my affairs.
Absolutely.
Okay, so those are the three things you need once you're an adult.
Yeah, those would be the basic recommendations, and I think all attorneys are going to say have something in place because you're an adult. You're 18.
Okay.
Even though, regardless of where you're living or who's paying for those living circumstances, and there can be situations where your parents aren't available or other people that you have listed, and that's why redundancy is important across the whole estate plan.
Right.
To be able to say, I'm not just going to have my wife or my girlfriend or my parents but I'm going to have all these other people listed as contingencies.
Totally.
Something
like
can happen.
Yeah.
Everyone's at Disneyland and everything happens and they're incapacitated somehow.
And it's interesting because, I think one is just have clarity, and two is because the alternative is that if it's not clear, if you haven't appointed it, then a judge is going to decide. And then what's the fastest way to have your family start fighting and bickering? It's like, one thinks that they should be the one making the decision. The other one is actually gets appointed, and then they're fighting and not talking, and that's not what anyone wants. Right?
All tragic things that could be avoided.
Right.
So, I recommend anybody that comes in that has real property in California, has some assets developing, has kids, should look at least considering a comprehensive plan. The trust is a great tool to avoid probate, pass on generational wealth, minimize these tragic outcomes, which is the tug of war that happens afterwards. And I think, a lot of your listeners now, or maybe that see this or listen to this down the line, are going to see the same thing.
So even if you don't have kids, if you don't own a house, you're just an adult, you need those first three items that we talked about. And then you said once you are married, have children, or buy a home, any of those three trigger points, whichever comes first, you need to start developing some type of trust. Yeah.
The larger, if you have no wealth, you have your car, minor bank account, maybe you're contributing to some sort of retirement, and that's it. Then maybe just a will and those other documents, advanced healthcare directive, and financial powers are sufficient.
Right.
But
once you have kids,
once you have kids, and
then you need something to say, well, if something happens to me,
sure,
what happens to the kids? Who's going to be their guardian? Who's going to actually look after them? So even if you don't own a home, you need to know and decide ahead of time. Sure. Otherwise, you wind up with everyone's families in court saying, we want to take the kids, or we want to take the kids, and we're not, and that just is ugly, and we can avoid that.
And unnecessary.
So have a plan.
You mentioned on another key buzzword there, guardians, right? So, a lot of my clients, the average clients are homeowners here in Sonoma County. most likely a bit of a mortgage left on the real property, but gaining equity. Children either at home or, they're empty nesters or half and half. Sometimes we have blended families.
Right.
We have all different types of things, all kinds of family dynamics, right? That's the reality of it. And, those are the most typical clientele that come in. And, they'll see bits and pieces and, hey, I need a will or I need this. And really once you start talking about, well, what are your goals? What are your concerns? And then answering some of their questions, we're able to kind of paint the picture a little bit more like, really, you don't know what you don't know.
Right.
So it's not just legal documents in estate planning. You can go on and click boxes, but it's really strategy, discussion,
right.
Prompting questions where people look at each other and go, we never really thought about that.
We had this. So my wife and I have a trust and all the other documents,
Good for
will
you.
and all that stuff. We got
Good
that
stuff.
stuff sorted out when our second child was born. We started the process when our first child was born, and we got busy because we had kids and everything else. But it was very interesting because we had to think about stuff that we hadn't thought about before, and having that kind of heart to heart. If something happens to me and my wife can't make decisions for my well-being, who do I want to be making decisions for me?
Right. And
we had to think about that. And then if they're not available or decline to act, right, who else would I trust to make these life or death decisions for me? And then also what I want to happen to me and what's acceptable care and not acceptable care. So it was really interesting to go through the worksheet that we had when we did ours, and a lot of learning between in our relationship, I think, happened. The interesting thing about that I learned about trust is that it's a living document. You can change it just because and you should revisit it, right? So just because you put someone in the trust that you think is going to be a great successor trustee, maybe they're not a great person 10 years later or 5 years later or something like that. So you really need to think about it and then have a plan, and then not just stick it in the drawer and be okay, got my plan, but know that you can change it and it's okay to amend it and alter things as life changes and dynamics change in relationships and everything else. So one thing I wanted to ask you was, there's stats right now for home buyers that there are more unmarried women buying homes than they're the second, besides married couples, they're the second largest pool of home buyers. So I guess the question I have is around premarital assets and how that plays into trust agreements. So if I own a home before I get married, I guess is the question. What is your advice around that asset and keeping that, in its own trust? How does that work if I wind up getting married and then we might have a marital home, but we have this other asset? Does that make sense? So
Sure,
how do you handle those assets that you come into prior to marriage?
Yeah, it's a common question, and it's the reality of things. People have assets prior to marriage. So a threshold thing is really, would a prenuptial agreement be appropriate? I've done those for clients in connection with estate planning. The other thing is you can have multiple trusts. An individual can have their own self-settled trust that handles that real property and those assets, but then community, have a separate one between the spouses or partners. This is all in design. So you're really looking at what are the assets, what are the context of everything. Is somebody going to inherit real property or other assets, which become personal property? And then you're kind of diving into, community property, family law stuff on how things are characterized. There's a lot of ways to ensure that those things are isolated in the court size in a legal way. And so there's not any commingling. Right. But that's all by design and comfortability. And any savvy attorney is going to be able to talk to you and discuss those things in a good environment to where it's not adversarial, but it's protecting everybody and really what's necessary these days. So
yeah, it makes a lot of sense.
So there's a lot of options.
So ladies out there, when you're buying your first home by
Yes.
yourself, because this is this is the thing, right? Maybe you want to keep that as your separate asset if you ever do get married in the future. have a plan for that and understand what you need to do to keep that as your sole property and not have it be moved into community property if you commingle and do other things like that. So talk to an attorney about those things and make sure you have a plan.
Yeah, and even if they want to consult separately,
right.
And just go, listen, I want to take baby steps and unpack this, and
Yep.
I want to get a trust. So they're just not. So if they have no estate plan, and even though they're married, and then they have this other asset solely in their name, and there's no plan, that's going to trigger probate.
Right.
And may have unintended consequences, and people bring children in from other relationships.
That was my next question, was
adoptions,
about on the other end of the spectrum.
All these things.
We have a lot of blended families,
Sure.
second, third marriages that we see in our profession, and I guess the question is like, how do you advise, for those folks who might have blended families and they're bringing unequal assets into a marriage? And in multiple homes, we see, we each own our own home. We're going to keep this one as a rental, and everyone's going to move into this as our primary residence. And how do you help families that are blending to have a plan for inheritance and what happens if someone dies?
Yeah. Well, that's part of probably the same process you went through as far as a checklist, right? We're looking at triggering questions about what are the assets. What are the ages of these people? How are they related? Are there any other means to provide outside of a trust or an estate plan? Also, you're looking at responsibilities for who's stepping up in this blended family. Sometimes there's mistrust.
Right.
Sometimes people are estranged, or they want to disinherit people.
Right.
And or sometimes people aren't the best actors to be in those roles, either as a successor trustee or an executor or an agent for healthcare decisions or powers of attorney. And they shouldn't be. Maybe they have capacity issues or, substance abuse or
Sure.
in and out of jail. There's just things that these aren't the right decision makers.
Totally. And I guess that goes back to make sure you understand who's in your trust.
Sure.
And who your successors are, because someone who you appointed 20 years ago may not be the right person anymore. So
Right.
you can always amend that.
And you, as you'd mentioned about, this has to be constantly revisited. It's just not paperwork, and you learn a lot along the way. It's, collaborative process when you're going through it.
Yeah.
It's not just a checklist, it's conversation and through the drafting process. And, that's the great value, I think, that there's the takeaway for families is they're educating about not only doing these documents, but how to use them, when to use them, what they are, that provides them with peace of mind.
Yeah.
And then just revisiting it. Like you had mentioned, whenever there's changes, you don't want to, have a dusty old document that doesn't work.
Right.
And you spend all this time and investment and you have a false sense of security because when it's time to use that thing's out of date, or who you nominated passed away or they lost capacity last year.
Right.
Or,
Yeah, that makes sense. What's your take on, so I've seen a lot of trust kind of when people die and then the successor trustee and the executor come in and kind of they're managing the trust and they're dissolving the trust. We get involved with some financing at some points for that. So what is your advice on how to choose a successor trustee, and how do you what advice do you give your clients there? And what are your thoughts on corporate trustees or third party trustees that are not family?
Yeah. I think to talk about that latter part there is who should be in the driver's seat, who's steering the wheel, and there could be a variety of things that make that decision. And it's kind of a discussion with the family members that come in. Sometimes it's individuals and they don't have anyone, they don't have family, they don't have people that are top of mind that they would trust. Maybe a neighbor that they've had for 30 years, but
Yeah.
Or someone they went to school with. And sometimes it's appropriate through that discussion that, hey, there's family dynamics here, or so-and-so is not good with money or decision making. They still have this allegiance to try to have the children do it, or sometimes, break it up so everyone's got responsibility so it feels good, that everyone's participating.
Yeah.
But in some instances, that's just not, the right decision. And that's my job. To have the discussion and say, well, this might be ripe to have a professional fiduciary step in that's perpetual, that's what they do. It's a company, and
Right.
they're bonded, and that's all they do, right? And you take the tug of war out of it, and all they're doing is affecting what you discussed that you wanted.
They just follow the document.
Right.
Right. And there's no personal feelings about it. There's no interpretation. It's like, this is what it says. That's what we're going to do.
Absolutely.
And I've witnessed a number of occasions where the executor that is appointed through the trust winds up just hating it. They're tortured through the process because someone's disagreeing with it and they're contesting it and they want to fight about it. And it's like, and then they're stuck in the middle, and it's like, well, I didn't write this document. The person who passed away did. I'm just trying to follow what they said.
Right.
And, so and especially if the plan has any loopholes or ambiguity in it, or some interpretation that needs to happen. I'm a big fan of, professional fiduciaries. I think in a way, if you have a certain amount of assets and people are going to, or that your family is just the kind who's going to, want to litigate about stuff, like just take the variable of family out of it and just appoint a professional fiduciary to come take care of it and follow the plan as you wrote it.
Yeah. And I think it's having that discussion to say, where are they at in establishing this plan? They may be later aged and their children are, middle-aged and going, listen, we already have a family. We're working full time.
Right. I've never met anyone who was like, yes, I was the executor and it was a fun time. I loved it. It was great.
Yes.
Like everyone is
it's
like,
a lot of work. It's a lot of work. Even if you do all of these estate planning documents,
right,
and everything's working synergistically, you got the trust, you have a pour over will, advanced healthcare directive, durable power of attorney for finances, disposition documents on, when you pass away, what do you want done?
Right.
And
like everything's vested correctly.
Yes.
There's no mistakes.
And
everything is dialed in.
It's still a tremendous amount of time.
Right.
People have to take time off or time work, but usually, well-drafted plans allow for appointment power or, that redundancy. So if and sometimes co-trustees or co-successor trustees, you have that to kind of assist with the burden and manage through it.
Co-trustees just seems like even more hard because then you have you can stalemate. You can go 50-50,
Yeah.
It's like I tell people I'm only in one partnership in my entire life, and that's my marriage because I've tried other partnerships and I just can't do it.
Sometimes they just don't work.
They just don't work,
in
my opinion. So, co-trustees sounds like even more of a nightmare. I mean, I understand why people would do it because they want it to be fair. I have 2 kids. I want them both to be, and that just seems like a ripe environment for conflict to fight over money and stuff. And it's like, just follow,
if I were to say anything, it's our job to tell people what they don't want to hear,
right,
but they need to know.
Yeah.
So,
I mean, you're dealing with what happens when you die.
Yeah.
Right. That no one has a trust because they plan to live forever. Right.
Or they just don't. They don't think about it. It's we have such busy lives, so much to do here in Northern California. You're working, you're having fun, involved in the kids' activity. I mean, we have the pedal down. So unless it's popped up on your radar personally in your orbit, or heard about it, or read about it, and a lot of clients that come in, they're like, we've been wanting to get this done for a long time, but they've kicked the can down the line.
Of course. Yeah.
And
then something happens in their life.
Yes.
They see someone else go through it. Someone in their life dies unexpectedly without a plan. And then they're like, oh, I better get my stuff together.
Yeah.
Yeah. So tell me, we'll go to the other side of what happens if you don't have a plan. So, people talk about probate, and I don't think people really understand what that is. So can you explain in very simple terms, like if you die without anything, you own a house, you got some stuff, and you die, what really happens and why it's something you want to avoid?
Yeah. Such a nasty word, isn't it?
Probate?
Yes.
I don't think people really understand
right.
what it really means. They just know that that's a thing that happens. Sure. And it's like this room that you go to or something.
Yes.
You gotta go to probate.
Yeah. It's, and there's been, stories on like Netflix or other stuff that are in the sphere of it. Sometimes they get it on point. Sometimes they don't. So I sometimes think it does the community some misjustice, but that's part of why I do a lot of public speaking, and I meet with brokerages and inform their agents at little morning huddles and section on aging, and wherever I can. Active 2030, I've done some sponsorship through them, and
nice.
Boys and Girls Club. to try to get some community involvement, give back, and do an educational component to it. You want to avoid probate. So whoever's listening, whether it's an agent, friends, the community, avoid probate proceedings at all costs. It's only going to get worse in California because of our aging demographic and the lack of resources in the court system. So probate is a process of validating your estate. And if you do nothing, right, regardless of what your assets are, there are different dollar amounts.
Right.
And there are ways, and that's in estate planning, right, creative ways of not having certain assets go into probate proceedings. Right of survival with joint tenancy. You do a payable upon death on your bank account, but then you want redundancy. So who else is in that car if something happened? If you do nothing, you go into probate court. You have to file that, hire an attorney, obtain the death certificate, file it, wait a period of time to get on the calendar, because the rising probate cases, just not in Sonoma County or the North Bay, but throughout the state,
Everywhere, yeah.
Is just going up, and they just don't have the same amount of resources. Typically, you have one probate attorney or one probate judge.
But if the person's passed away, that means everything stops. Because if you don't have any of those check writing abilities or anything like that,
Right.
that means that everything gets shut down.
Absolutely.
So when the mortgage payment
Yes.
still has to be paid,
Yes.
someone has to pay that.
Yes. And that's that is a reverberating problem.
Right.
So in some instances, if there's some sort of exigency, it's possible to, in limited circumstances, request an ex parte order, which is bypassing that, goes right before the judge, to get some special powers to maybe deal with
Like,
a mortgage.
hey, I need cash now to pay the bills that are coming in. So I don't need access to everything, but I need access to this one account that's got some money in it.
Right. But that's rare.
Okay.
Usually what happens is, someone's passes away, whether it's expected or unexpected, and, it triggers probate because they hadn't done anything. And the wheels keep turning, that's great that you have things on auto payment, and, that's a blessing. But if not, then, you have defaults on things, a storage unit, your mortgage, some sort of insurance, utilities. Okay. That just causes a whole other cascade of problems that could be avoidable. So when you're in probate, you're looking at, a period of time to even get this heard, and then before a judge, which could potentially continue it because of case issues. And you've hired an attorney to go in there and do that. And then if letters are issued, then you have to then move forward in inventorying all those assets, getting appraisals, collecting those assets, paying off creditors, dealing with taxes.
Right. So, but
this doesn't sound exciting.
So who is doing that? So, okay. So let's just make up a scenario.
Sure.
Dad dies, and you've got 2 kids.
Sure.
3 kids, whatever it is. So somebody, one of them is like, hey, I'm going to go start the process of probate because I want to get access to, we got to do something with dad's stuff.
Right. The question is who's entitled to petition for probate. There's a list.
Okay.
Much like there's a list of who could get things, is California issues all these default lists in the law and the probate code. So if there's no will, then who would be next is a surviving spouse, then children.
So what if there's
could petition.
2 or 3 kids and they don't trust each other?
Sure.
And
Which
all
happens.
3 of them petition at the same time.
Sure. Then there would be an evidentiary hearing, and the court could potentially decide, or they can, maybe look to see if, all right, maybe we need to appoint a private fiduciary or a personal representative.
This sounds very complicated.
Not only complicated,
very
but
expensive.
unnecessary.
Yeah.
And then look at all, you're already dealing with the loss of a loved one.
Right.
Whether it's expected or not, it's traumatizing.
Sure.
And you're having to deal with final disposition. And sometimes there's tug of war on that. The cost, of disposition, just a cremation is expensive, right? And then if they're being buried and, all those decisions, it kind of goes back, to preparation. If you prepare for all this stuff, even if your kids may or may not agree with it, you've prepared it. I always encourage, if the cookie's not going to break evenly, or if there's some decisions they, for whatever reason, politically or, their philosophy or moral that you draft a letter to each of them, maybe even do a video on why you made these decisions. So there's some understanding. It's just not on paper when they go, hey, mom or dad wanted this.
Yeah, we got a 70-30 split, and now
why?
I'm never talking to you ever again.
Yeah, and why?
And why? Yeah.
And sometimes there's some decision rationale behind it, like, hey, you're established, you have a family, got a great job.
Right.
Dave over here, John over here, that's kind of struggled, and but we've structured this payout to where it's going, the distributions are sprinkling, it's going out, incrementally, and not just cutting someone a big check, right? So
because we don't trust your brother not to blow his inheritance.
Yes. Yeah. Estate planning's, almost like a game of chess. It's not checkers. Everything's methodically moved. There's a plan for every asset, and there's redundancy to the extent we can, and it's a plan. So those, it's a game plan. Things change at halftime. We got to reassess. The laws change. Family dynamics, marriages, kids, assets. So all those are factors. But I think it's one of the biggest return on investments, and the right thing to do for people that you leave behind. I've just seen night and day, and it's one of the most rewarding things is when, clients leave, not only with the peace of mind and the documents, but they also are, they know what to do with them.
Okay.
It's just not, hey, we got this up here, but they know, okay, hey, this advanced healthcare directive, I got to scan a copy to my doctor. I need to give a copy to those agents. So if something happens to me, they have the document. They don't have to go rooting around for where's the binder? Dad told me, this. So,
oh my goodness, it's very. So going back to the why you need to avoid probate, I think we've already established that it's unnecessary, expensive, and time consuming.
Absolutely,
and adds a lot of complexity to an already tragic time in most people's lives.
Yeah,
right?
If you're going into probate proceedings, you're looking at anywhere from 12 to 18 months realistically in California. That's a snapshot right now when we're doing this podcast in 2026. It may
maybe different in the future, maybe longer, shorter.
Yeah, I anticipate it's only going to get longer.
Yeah, because like you mentioned earlier, the silver tsunami is happening. The baby boomers are getting older, and there's going to just be a lot more of need for estate planning and probate if people don't have plans, and limited resources going into the type of courts that are handling this. Yeah. So especially if you've got complex, because I'm imagining maybe I'm not. I looked at the data.
Yeah.
Like 12% of Americans have a trust, something like that. So that means that like a lot of people wind up. They might have a will, but that's not inclusive of
still
everything.
Goes to probate. Yeah.
Right. So there's a lot of people who are unnecessarily going through a very expensive, difficult process, and if they took the time to meet with a trust attorney and created their plan, then they could avoid all of that expense and actually have a better outcome for their family and their heirs. That's going to avoid conflict as much as you can. I think there's always conflict in families, especially around money. But you can try to avoid that as much as you can. And like you said, having that letter or the video or like the rationale or some type of explanation, that way it can be like, well, maybe I don't like this, but I can actually see why why mom and dad decided to do this. And that's okay.
Yeah.
What mistakes do you see besides not having a plan? Right, that's probably mistake number one. But what are some common mistakes that you see people making in their estate planning?
I would think the most common mistake is they try to do it on their own. They either chat GBT, AI, do something on Google.
There's a ton of resources online, right?
Sure.
You can Google and you can do some online forums. And
there's some self-help stuff out there.
Yep.
Some of them, are not California compliant. Some, are so wordy and people don't understand with the legalese. It's not broken down and digested for them to make an informed decision about what they're doing. They think it's one thing and not another. There are a lot of the do-it-yourself checkbox ones, and you print it, and you're getting some value there. But there's certain things in life I would not look for value on. I'd look for, and legal guidance is one of those things you don't want to go skimpy on. So I think that's one of the biggest mistakes is looking for value and rounding corners to try to fulfill the needs.
Right.
If you have nothing, if you and I get it, everyone's got different means,
Sure.
but do something, right? And, there are some modest means programs in various counties, and, a lot of us attorneys do pro bono stuff. A lot of us hold free workshops. I hold free workshops every month at my office where it's, come on in, learn about it. Learn about what the different tools are, and then just start the conversation. So I think that's the biggest thing, is get educated about it and what you need, versus, going to online and perhaps doing wrong type of estate plans. The other big thing is, with real estate, is maybe adding children on too early, and, changing title and changing ownership. And they may not know the ramifications of how that may trigger a reassessment, might trigger acceleration clauses in mortgages, a variety of different things that can happen. And once that's done, very, very difficult to unring the bell.
Yeah.
So,
Yeah, we get some questions about that, and I'm always like, you know what? You need to talk to an attorney.
Yeah,
because
not a generalist attorney that practices in 15 different areas. Somebody that's that knows what they're talking about. And there's a lot of competent attorneys in this area.
Yeah,
so
totally. So going back to talking about like a lot of our clients are first time home buyers, right? So we talk about how they're going to vest their property. Which we've done in an episode prior, so we could reference that in the show notes about different types of ways you hold title.
Yeah.
One very common way is to hold it in a trust, and a lot of times our clients haven't thought about, having their trust established prior, having that document in hand prior to buying the house. That happens like subsequently to buying the home. So that's kind of a trigger that we use regularly to be like, hey, now that you're a homeowner, like you need to have. If you don't already have a plan, you need to have a plan, and here's the reasons why. So talk to me about like how changing the vesting from one thing to the other, common questions. How does that change? Does it change anything financially for them? Does it have to reassess their taxes? Does it have any of those like financial implications?
Yeah, that's a great question. I think just to back up just a little bit is, first-time home buyers, they're typically getting pre-qualified, then they are engaging with real estate agents looking at various properties, and they're excited about that, as they should be. It's the biggest, one of the biggest decisions, besides maybe kids and other things, right, that someone does in a lifetime.
Yeah.
And whether it's their investment home or their forever home, they should really try to consider establishing a trust ahead of time. And then that way, when you make the purchase, title can go ahead and title it straight into the trust. Now, not an issue if you purchase the property, you've got it mortgaged, your property insurance is all titled, how you took it when you purchased it. You can establish an estate plan and trust afterwards, and then we simply just do a grant deed to the trust. And then I fill out all the P-Core documents, the preliminary change of ownership documents with the county. That gets recorded. And there's actually a box on there, and I'm sure most of the real estate agents and community knows that there's an exemption for that. So if you own it and you're just merely putting in your trust, even though that is a change of ownership, that would typically trigger a reassessment. It's a transfer. There's an exemption. And then once that's done, then you're really just talking to the mortgage company to give them a heads up. Who knows if they ping the file, if your property taxes are impounded or anything, they see, hey, there's a change of title. Always good to give them a heads up. And big issue is, and we learned this really out of the LA fires, is make sure that you contact your property insurance and let them know, hey, we want to add the trust as a rider on the policy.
Oh, interesting. I hadn't considered that.
Actually,
go back and look at my policy now.
That was the biggest, challenge in LA is, hey,
right. Because our homes are vested in our trust, and then, so we everyone's aware of it. But when we took the mortgages out, that was prior to the trust existing. Yeah. So I don't know if we've actually notified our insurance company. I'll have to call my insurance provider and be like, hey.
Just
so you know, this all has to be on there. Because I also get questions about is it going to make my note due? Is my mortgage going to get called because it's changed? No, it doesn't. That doesn't happen. Yeah. But it is. Yeah. So you don't. It's best practice to have it established before. I don't think I've ever seen a first-time home buyer
The only time I've ever seen that is usually if their parents or somebody else is helping them, either with the down payment or the costs involved, and kind of shepherding them through the process, and they have a trust.
Right.
They might talk about, hey, listen, you guys are together. Let's provide some security here, some stabilization. Then they establish that. But in some instances, and often is they buy it. That's already the big hurdle. They're working full time to get this done, and then they invest the time to develop the estate plan.
Okay,
and that's over a series of appointments, consultation.
Yeah, I was going to ask those.
Drafting.
Yeah. The next question was about. So someone contacts you today,
yeah,
and they're like, "Hey, we heard the podcast. Thanks for doing that. We want to get started."
Yeah.
How long does it take to get your trust, like from first consultation to, deeds of trust and stuff being transferred?
Sure. I like to use the legal thing that we always use.
It depends.
It depends. It depends. It sounds like you're very, very familiar with it, right? It does depend. It depends upon how clients are motivated, how motivated they are to get this done, right? We set a consultation, usually have them bring their list of goals and concerns and, where did you see me? Did you see me on Yelp? Did you see me in Sonoma Magazine or the Press Democrat?
One of the awards you've won recently,
Yeah.
perhaps?
Yeah, any of those, right? What brought them in and what triggered them to have the conversation? Did they come to a workshop or referral? Listing agents or wealth managers or CPAs. I work with all of them that are referral partners because it really takes a wraparound services for the client. And so, after that first conversation, which is, usually just 30 minutes to be able to have those discussions, and we put it into gear, they're then given a checklist to, hey, collect all these documents. How do you have the grant deed in your retirement and, all your assets? And so we do more of a intake, which could take anywhere from an hour to 2 hours, depending upon what their assets are, how well they've prepared for this, and whether it's an individual or a family and what the dynamics are. We do that intake, and usually 7 to 10 days I'm able to draft in a well-organized binder, tabbed, digestible, for the client to pick up and then go through and review. And part of that reviewing process is they're reading it, understanding or not understanding, and asking questions, which is always great. And they're involved in the process. So once that's done, usually there's a typical lag time from when they pick up the draft, get it done, and then get back to me. You don't want to push that process, but you also don't want them getting that far and not getting across the finish line.
That was my experience when we started ours.
Right, because life gets busy.
We had a draft and we sat on it for, I don't even know, it could have been a couple of years, honestly.
Oh, yeah.
It was a long time.
Then it's almost redrafting
to the fact where we went back and we're like, things have changed.
Yeah. Now
we have to kind of revisit this whole thing. And fortunately, the attorney we're working with, who's since retired, so shout out Bill Fishman if you know Bill. He was very kind, and it wasn't the first time that had happened. You could tell, and he's like, okay, so now we got to revisit it, and this time we're going to see it through to completion. Like, yes, sir, absolutely. So, so it's very common, I think, for people. It's a lot of decisions, and it's one thing to have a draft of it, another thing to like sit down with a notary and sign a bunch of stuff and be like, yes, if something happens to me, I trust this other person who's not my spouse or not my partner to make a decision about my health, and if we die in that fiery car crash thing and our 3 kids are left behind, we trust these people to watch our kids until they become adults. Like, that's a big freaking decision. Yeah. Right. So I totally understand why people would balk at, signing it and just sit on a document.
Yeah.
But you have to sign it. It's not worth anything unless it's signed.
Well, not just signing it, but then, drafting, we sit down and do the signing ceremony, and, that's going through a notarization process, and there's a lot of great notaries out there that a lot of us use. I use Fell Notary, mobile, bilingual, very helpful, puts people at ease. They're great. And I think once you're done with that process, then it's a shopping list of, take this to the bank to retitle the account.
Exactly.
Take the grant deed over to the recorder, do this, do that. And then so you fund it, right? That's step 2. So worst thing you can do is just do the paper and not take the next step to retitle assets. And then, depending upon how much handholding or assistance they need.
Right.
We help them out with that process. So that, I mean, it's an investment of time, but it's digestible in small pieces. I think people are maybe intimidated by it, or there's the myths, as you mentioned at the very beginning of the podcast, about this is only for the wealthy or big assets. There's an estate plan that fits for everybody.
Right.
And just like car insurance and some of the other things, you may not use all those tools that are in there. You may pay the premiums forever and never use it. Same thing with the estate plan. You'll use it at the end, right? Because Father Time has a 100% success rate. We're all going to pass.
It's true.
Right? But there's some documents there you may or may not use because you may never fall ill and need that.
So what happens? So like, our trust just, it's like 2021, I want to say is when we signed everything. And some of our assets have changed since then. We might have moved some accounts from one bank to another. Every time you make a financial, change, or you move your money from one brokerage to another or something like that, do you need to go and redo your entire trust? What is the best practice for that?
Yeah, that's a great question. And a lot of it comes down to drafting. If they put specific gifts within the body of the trust, which I'm not a proponent of, because if you do have those things, you got to go back in and amend the trust. You just can't line something out.
So if I say $100,000 from this specific account is going to go to this person, and that account doesn't exist anymore,
right?
That's
Or here's my 65 Mustang. I wanted to go to, and you're listing that in the trust. It's then you're having to amend things. The Schedule A of assets, which is just basically, for layman's terms, just a list of all your assets that are in the bucket of the trust. That's the most commonly modified document. That's one document. It's really easy to just go, hey, we've had these changes. Can we just update the Schedule A? It's one document.
Right.
And then you have a personal property list for those specific gifts, mom's jewelry or these family heirlooms or those things that you don't have to, that you can update regularly without having an attorney involved. So, that's just part of educating. How do I do this?
Okay.
And, I always tell my clients, hey, I'm neighbor first. That's my, my philosophy and why I do this niche. And so call me,
right.
Get a hold of me. Let's figure it out, because I would rather you have that conversation and get it right than make a mistake that is more costly or has different outcomes than you really wanted.
Right. So like, let's say I have I have my plan, and then I open up a new savings account, and at the time of my death, there's, a couple $100,000 in the savings account that's not titled in the trust. Mm-hmm. Does that go to probate?
It depends.
Okay.
Right. So, when I talked about the chessboard, you could have a lot of assets titled in the trust. Then you acquire some other assets that either were not named in the trust. But there's a lot of ways to keep it outside of the trust and outside of probate. So if you had that bank account and you named powers of beneficiaries, POD accounts, then it would go to those people. It would never go into probate.
Right.
But
if I didn't do that,
I always try to explain to people, do a POD, a secondary, and then always have the trust as a contingent. So then if so-and-so passes away or you never update, at least there's that parachute or that safety net that the successor trustee can come in and collect that account and never goes to probate.
Got it.
There are some tools, it's called a Hegstead petition, that an attorney can file in probate court to not open a full probate, but be able to say, listen, here's all these assets in the trust in the bucket, right? We had a couple outliers here, but they had intended to really put, maybe the Schedule A asset says, ABC bank account.
Yeah.
But it's not retitled. It's a small, step, but you can draft this petition, basically show the judge, hey, they established this trust. They had this asset, either was in existence at the time or afterwards. They had intended to put it in their trust.
Right.
And it's a low threshold because really the court really wants to ensure that, hey, the settlers' interests were fulfilled, and this is what you wanted to do.
The plan was followed.
Yeah, the plan was followed, and you don't want to clog up the court for some of these things. So they're encouraged to try to, if there's a way to do it, to be able to do that.
Isn't there a way to say and anything else I've forgotten, stick it in there?
Yes. Yeah. Well, I mean, usually it'll say, here's the list of all the assets.
Yeah.
And everything else that I own, tangible personal property and whatever, kind of a catch-all. But sometimes it could be problematic when, what was that asset? What's the value of that asset? How is it, characterized? How's it titled? A variety of different things. So you start getting into those nuanced stuff. But all these things that we've talked about, all these bad outcomes, can be completely unavoidable or completely avoidable with estate plan. The trauma on others, the closure happens a lot quicker if you have an estate plan versus a lingering probate, where you're always having to communicate with each other on these issues, and the attorney and the amount of time and money involved. You're looking at in California, 20, 30, 40,000 in just basic probate fees out of the estate versus a fraction of that for an estate plan. To me, it's a no-brainer.
Yeah, no, it makes total sense. Where we run into trust often is where, grandma's passed away, for example, and one of the grandkids wants to buy the house from the estate.
Sure.
Right. And it's not specified that the house goes to that granddaughter, but they're like, hey, it's part of my, I get something from this, and I want the first right of refusal or whatever to be able to buy this house. And it gets very complicated because it's there might be competing interests and other things. So I think, again, going back to the original point of having a good plan, revisiting it, and then making sure the people who you're choosing to oversee the trust upon your passing have the skill set to overcome those things. Because there's a lot of pressure. There's a lot of competing interests. There's a lot of opinions that get out there. Yeah. And, you want to make sure that you have someone who's going to follow what your intention is, and then also have common sense to figure out the best path that's going to fulfill the document, and not put them in a position of hey, now that I've done this, everyone hates me.
Sure.
Anyway, maybe I've seen too many of these go bad.
There's a lot of that stuff, and you see a lot of these outcomes, Britney Spears or some of the other ones that got conserved. Well, if you had an estate plan, if you lost capacity for any reason, you could have nominated those people. So it avoids conservatorships, guardianships, going into court, getting authority to make medical decisions, all of these protracted processes and costly processes. So, to me, that's one of the main things that reasons why I got into estate planning is not just because it's transactional. It's a feel-good area of the law that everyone gets a sense of security that things are going to be handled, and not seeing these traumatizing effects afterwards, costly, the time, tearing apart families, all unnecessary. So, whether it's real estate agents that are listening to this, I think the best thing is whether you have a new client or a perpetual client, is you have that conversation. You're giving them more value to say, hey, I'm not just selling you a house,
right?
But a good thing that you might want to do to protect this huge investment is consider putting it into a trust, creating a whole trust plan. What happens if one of you pass away? All those things. And I think that's one of the things that, is overlooked sometimes. They're looking just at the transactional stuff, and not to say that people just fill out the car forms and
see you later,
move forward.
Just trying to get my commission.
Right.
I think many people do that.
Yeah, but a lot of the agents that, especially the ones that have been here longstanding, is they get referrals, right, from these transactions, family, or they're doing generational transactions. Yeah. So, what better value can you give them to say, listen, hey, I work with an estate planning attorney, or work with this, to like I said, wraparound services, and how appreciative they would be of that.
Totally. No, we get into the weeds with our clients and make sure that they understand how they're vesting, and make sure they understand why you would need a trust. And we also talk to them about life insurance.
Yes.
I think it's an overlooked thing that people do not take into account. And the problem is that they're just spending all this money. Yeah. A starter house here is, $1 million. Yeah.
Yeah.
So you just spent all this money.
Yeah.
And then it's oh, by the way, I also need you to spend thousands of dollars on a trust plan.
Sure.
Cool. Also, you need this new life insurance policy. So this goes into your monthly, debt. And congrats on the house, by the way.
Yeah.
And
it's and here's the bottle of wine and
exactly.
The keys.
Here's the cutting board. Have fun.
Yeah.
So it's a hard conversation to have, but I think it's necessary, and it does, even if they don't decide to do it immediately, right? Even if it's a year, 2 years after they buy the house and they're kind of like, comfortable in their payments and stuff, like know that this exists, and then have a plan to get a plan, right? So like, even if it's not, obviously right now is better, right? But even if you can't do it right now, know that this needs to be part of your future plan, to save money for it, to put your documents in order, because you don't want to get caught without this. This is super avoidable, and you don't want to put your family through it.
Yeah, and I really think, whether you're a first-time home buyer existing and you're doing a 1031 exchange or downsizing, any of those options, those are all great times to be able to look at and reassess. So it's really for everybody. Yeah. And then as far as, to speak to the costs of it, it just depends. Most estate plans in California, they're all flat fee, and they, comprehensive, and that's a drop in the bucket. And I think a lot of estate planners are, willing to remove a lot of the barriers to that and do either, a couple of payments, or, flexible on, how they want to be able to do that. Because at the end of the day, you want to be able to make sure that they're taken care of. Yeah. And, if you can be flexible on that stuff and work with people where they're at in life, and provide them that sense of security, that they're going to remember that, and they're going to talk to others and promote you in the community. Totally. And when they see your face or your name, they're going to say, yeah, I had a great experience with that person. And I think that's what
you're doing, Brett.
Helps you move up a little.
Yeah. So if someone wants to get started, obviously you're offering, 30-minute free consultations, right? That's like a complimentary first 30 minutes, kind of get the ball rolling. And you offer a bunch of seminars and education things. So I'll make sure that people know to go to rhodeslawca.com, which is your website, and reach out to you. You're active on social and other places. So they can either schedule a one-to-one meeting with you, or sign up to attend one of your free educational courses to kind of walks them through some of the high level things and gets them started on the process. Any other advice that you have for listeners out there that they should be thinking about?
Well, I would just say, start the conversation. You've listened to this, as maybe triggered something, or said, we got to do that. Don't be one of those that go kicking it down the line and wait, and we'll wait. We'll do that down the line. It's all shuffling the priorities. We recognize everyone's busy. We're all busy. But really setting that time for a consultation, either in person. I do virtual ones in the evening. From the comfort of your home, we just hop on the call for a little bit, make it easier, remove those barriers for busy lives and families. Again, the workshops, spring is in the air. Aside from today, we're getting a little rain today.
Raining today, yeah.
But we're going to have great weather. So, Fridays, last Friday of every month, in the evening, for an hour, just do a workshop, having these discussions, doing a PowerPoint about the different outcomes, baby bites. So people are always welcome to show up to those. Those are all usually marketed on my Instagram or website, so that's easy to find. So I'd say just start the baby steps. It's not intimidating once you get started. A whole lot of return on investment. And I think
And I think you just sleep better at night, honestly, knowing that you have a plan. Like, I know, like, we have life insurance, and we have got a trust, and we've got things like pretty well taken care of. And we've got a plan for what happens. Sure. And it gives you peace of mind just to know, like, hey, I don't know what's going to happen. There's awful things that happen every day. Yeah. And it hasn't happened to me yet, but at one point it will. Right?
I mean, we all read stuff in the news. Right. I mean, whether it's, on social media or in the newspaper, all these tragic things happening.
So don't die without a plan. Yeah. Like, have a plan, please.
Exactly.
Yeah. Your family will thank you.
Yeah. Or get in touch with me, whether it's a real estate agent, a broker that wants me to come do a presentation, any other, myself, others, we're all happy to try to help in the community to kind of raise the awareness and try to do some of the things that we could do to avoid these.
Absolutely. Yeah. Cool. I'll make sure all your contact information is in the show notes. Thank you so much for all this education and information. I know the audience will definitely appreciate the episode. Thank you for your perspective on things. And if you do need help with your estate and trust plans, please reach out to your local trust attorney. If you don't know anyone, obviously call Brett and he'll send you the right direction. If he can't help you, I'm sure he knows lots of people who can.
Absolutely.
And thanks so much for being here, and we'll see you soon.
Yeah, thanks. I appreciate the opportunity.
For sure. Thanks, Brett.
Stay up to date with Bay Area real estate. Hit subscribe now if you haven't haven't already. Did you enjoy this episode? We love reviews in the Apple Podcasts app. We'll read yours on the show. This is By the Bay.